Court has wrapped up for the day in Lower Manhattan in Donald Trump's hush money trial.
Trump is accused of falsifying business records to cover up a payment during his 2016 presidential campaign to adult film actor Stormy Daniels, as we've been covering. The prosecution says, though, that this was part of a scheme to corrupt the 2016 election. Let's bring in, as we just teased before, CBS News national correspondent Errol Barnett, who is following every detail of this case from Lower Manhattan. Errol, talk to us about what just happened. Where did it all wrap up?
Well, as you saw just within the past, 30 minutes or so, President Trump again speaking to cameras as he left the courtroom. And the last thing that jurors saw today was the testimony of David Pecker. He's the man who ran AMI, which was a publisher of the National Enquirer, a tabloid, which was part of this overall catch and kill scheme to purchase the rights to certain stories and then effectively put them in a safe lockbox and prevent it from being known to the public. And what we heard from David Pecker was what he described as, quote, checkbook journalism and the ability to have sources in hotels and other places that would have links to or knowledge of what celebrities were doing. So this kind of helps put the contours around his role in this overall scheme that the district attorney and prosecutors allege that Donald Trump was a part of when he became president and wanted to hide stories of alleged affairs between him and a pornographic actress a decade plus ago. I want to bring in CBS News legal contributor Rebecca Roiphe because she also listened to what the president said when he left the courtroom and can help us understand where things now appear to be at the end of day one. Rebecca, do you think it may have been strategic on behalf of the prosecution to have the last thing the jurors heard today was David Pecker essentially underscoring the contours of what are catch and kill schemes?
Absolutely. So lawyers in a criminal trial are often thinking about when the jurors go home, what they're left with, how the thoughts linger in their mind. And so it's definitely a strategy to think about conducting your case in a way that leaves them with important moments and things to think about.
And what do you make of how the jurors have now entered into this really unprecedented case? It's not just the first ever criminal prosecution of a former president, but for them, it will be the most amount of media attention they may have seen in their lives. We know that today's proceedings began with one juror saying that after what they witnessed Friday and all of the media attention, they're just not sure that they can continue. Judge Juan Merchan decided that that juror could participate and could still be involved in what's happening. From your point of view, how intense an experience is this already for the 12-seated jurors and the 6 alternates all watching this?
Well, this is an incredibly intense experience, as you say. You know, jurors in any case, I think the weight of the situation when it's a criminal case is significant. The courtroom, the process, the ritual, brings that home. But of course, this case multiplies that any number of times because of the weight of the case, the import of the case, its potential effect on people who are voting in this election and their feelings about the candidates. So obviously, all of those things. And then you add to that, we have a president who, when we talk about unprecedented, it's almost like we overuse that word, but it's worth focusing on the fact that we have a former president who is a criminal defendant who has also, used his platform to really undermine these proceedings and to say things about witnesses and about jurors in other cases that have, are problematic and potentially threatening. And so, I think that also must be weighing on the jurors who at least are aware of that and somewhere in the back of their mind. But, the important thing to really note here is that jurors tend to be really good at putting all of the things that are irrelevant in the back of their mind and focusing on the evidence. But as you say, I do think it's something to look for because we have 6 alternates here. Is there a possibility that along the way, the pressure becomes too much for one or more of these jurors? And could we actually see a situation where we run through those alternates? One hopes not, and I don't expect that. That would be quite unusual, but it is a possibility.
You mentioned the criticisms that President Trump has made to the process, the judge, witnesses, relatives. He, in fact, is under a gag order, which will be the first order of business on Tuesday, which further abridges what the jurors will be able to listen to, as again on Tuesday it adjourns early for Passover. I want to get your response to news that was made here this morning when Judge Merchan decided that if Donald Trump takes the stand, as the former president says he will, the judge explained the contours of what the prosecution could ask him. He included quite a number of other cases in New York, other examples of speaking out of turn, contempt in court, that can be included as part of that questioning. Did that surprise you? And what risks does that pose now for the former president if he does decide to take the stand? The E. Jean Carroll case, for example, is one thing that can be included.
Right. Here in New York, we have what's called a Sandoval hearing, in which the prosecution has to put forward what it intends to use as prior acts to cross-examine the former president if he should take the stand. This is meant to inform the defendant's decision about whether to do so or not. And this is an incredibly weighty decision because not only does it affect the choice of whether a criminal defendant takes the stand, it can also be a very significant appellate issue because what the court is weighing is the value of this evidence, how important it is to the case itself, how relevant it is to the case itself, and weighing that against its potential prejudicial effects. And so that's a delicate balance. That is not a formula. And sometimes a trial judge can get it wrong. And that does expose the case to a potential appellate issue. And so, it's a hard call. I think the judge did a pretty good job of weighing what will be, critical and important for the prosecution to make the case and keeping out some things that would be unduly prejudicial.
Now, it becomes a moot point if President Trump decides not to testify. That is a highly risky decision on his behalf because he wants to seem credible to the jury who will decide whether or not he's guilty of these 34 felony counts. But if I listen closely to what you're saying, you're suggesting that after that Sandoval hearing and now knowing what Judge Merchan has allowed the prosecution to include as part of their questioning, it actually does open up an area of appeal for Team Trump if they don't agree with the outcome of this trial down the line.
Absolutely. I mean, this was a key issue in the Harvey Weinstein case here in New York, where, exactly the same issue. And the judge ruled that certain prior bad acts that were not charged in the particular case were admissible. And that is still pending on appeal. So, it can be a very important issue. And of course, Judge Merchan is a very experienced jurist and, has thought about this, of course, in a serious way. But it is always possible that an appellate court could view this and disagree with his choices.
Our CBS legal contributor Rebecca Roiphe joining us there to discuss the latest. Thank you very much, Rebecca. As the former President Trump exits the courthouse today with the end of proceedings, Ben and Lilia, you watched this all as well. A noteworthy first day of testimony inside the courthouse behind me, an abridged version for the jurors who now go home and digest all that they've heard. And folks will resume at around 10 or 11 a.m. Tomorrow.
And things will likely get more interesting as the week goes on. Errol Barnett, thank you so much.
Yeah.